Sweet Nigel.
Madam Clerk, please call the roll.
Representatives Baum, Camper, Cochran, Faison, Garrett, Hawk, Hazelwood, Love, Moon, Shaw, Whitson, Williams, Chairman Hicks.
Here.
You have a quorum.
All right, thank you very much. Members, I know we've already done this once, but I'll say if anyone has any personal orders or any announcements. Seeing none, we do have a total of 16 bills on our calendar today. We're going to begin with item number one. Item number one on our calendar is going to be House Bill 77 by Leader Lamberth. You have a motion and a second. And there are several bill amendments that have been filed to this bill. We'll begin with amendment drafting code 009611. Of the chair lady. Chair lady Hazelwood is carrying amendment 1, drafting code 009611. Do we have a motion and a second? We have a motion and a second. You are recognized.
Thank you, Mr. Chairman. This amendment recognizes the revenue loss due to the removing the sales tax on gun safes as established by House Bill 7012. That's a recurring revenue loss of $1.6 million. This amendment also provides $1.1 million non-recurring basis for the Department of Safety to create a public safety awareness campaign on gun storage. With that, Mr. Chairman, I would move approval.
All right. Thank you, Chair Lady. Members, you've heard the description of amendment drafting code 009611. Any discussion? 009611. Any discussion? Hearing none, seeing none, we're now voting on amendment 009611 onto House Bill 77. All those in favor, please say aye.
Aye.
All those opposed, no. The ayes have it. We're back on the bill as amended, and that brings us to amendment number 2, drafting code 009612, also by Chair Lady Hazelwood. Do we have a motion to second? We have a motion and a second. Chair Lady, you're recognized for a description.
Thank you, Mr. Chairman. This particular amendment provides $10 million on a non-recurring basis for additional school safety grants. These grants are specifically for public charter schools and schools within LEAs that don't have a full-time SRO for the upcoming school year. The grants will be administered by the Department of Education. With that, Mr. Chairman, I would renew the motion.
All right. Thank you, Chair Lady. Members, you've heard the description of amendment 9612. Any discussion? Chair Lady Hazelwood.
And I forgot an important piece of this, and I'm so sorry. But there's $30 million non-recurring that will be allocated for higher ed safety grants. And that is for all institutions of higher education.
All right. Any discussion? Representative Love.
Thank you, Mr. Chairman. I'm just trying to follow in this amendment where the higher ed piece is. I may have missed it.
Give us just a second here. I think we may have got that one. Yeah.
Mis-
Yeah.
Mr. Chairman, I do apologize, but we've had a bit of confusion in the way that our amendments are listed here. So we're gonna, if you will just give us a couple of minutes
Yeah,
to
absolutely.
get these straightened out, and I will do better.
Yep. Give us just a second here. We'll get this straightened out, make sure we get this right. All right, thank you for your patience. We just want to make sure that we have everything in order before we proceed. So we are, let's just get where we are right now. We are on amendment number 2, which is drafting code 009612. We've had a motion and a second. Now we're going to go to Chair Lady Hazelwood for a description of that amendment.
Thank you, Mr. Chairman. Initially, the bill or the appropriations amendment had $16 million non-recurring for recruitment and retention bonuses for behavioral health professionals that work for either a treatment agency that contracts with the Department of Mental Health. This amendment reduces that to $12 million rather than 16, allowing us to do some other things with that additional funding. So with that, Mr. Chairman, I would renew my motion.
All right, thank you, Chair Lady. Members, you've heard the description of House Bill Amendment 9612. Any discussion? Leader Camper.
Thank you, Mr. Chairman. Thank you, Lady Chair, for bringing us around to getting on the same page with these amendments. So with the 4 million that you're reducing it by on a non-recurring basis, have you thought about where these 4 million would be applied? Will we see that later, or how do you expect to deal with these $4 million?
Yes, we're not reducing the total. We are just reallocating some funding, and you will see that in these amendments.
Leader Camper.
So we expect that this 4 million that we're reallocating will be reappropriated with a subsequent bill that we're going to pass while we're here in special session, or where are you seeing us moving this $4 million to? Where's my pen? I have one right here. I thought it was. Oh, thanks. Oh, sorry about that.
Leader Camper, the $4 million, we're including that in Amendment 9612. In addition to any other funds appropriated by the provisions of this act, there is appropriated sum of $4 million non-recurring to the Department of Mental Health and Substance Abuse Services for the Behavioral Health Safety Net program. So that's where that particular $4 million is going.
Okay, thank you so much. Thank you, Mr. Chairman.
Thank you, Leader. Further discussion on Amendment 9612. Hearing and seeing none, we're now voting on Amendment 9612 on to House Bill 77. All those in favor, please say aye.
Aye.
All those opposed, no. The ayes have it. We're back on the bill as amended. That brings us to Amendment number 3. That will be Amendment Drafting Code 009634. We have a motion to second. We have a motion to second. Chair Lady Hazelwood, you're recognized for a description.
Thank you, Mr. Chairman. This is where we ran off the rails earlier. I apologize. We are back to the $30 million non-recurring that is going to be allocated for higher ed safety grants. And again, that is for all levels of higher ed. That includes our TCATs, our community colleges, and our public and private colleges in the state of Tennessee. So,
All right. Thank you very much for this description. Members, any discussion on the amendment? Representative Love.
Thank you, Mr. Chair. And just trying to get some clarity on what this would be used for. And I was following the Section 60, Item 25, and Section 60, Item 26 of Chapter 418, looking at that for what's expected. I know when we passed it for our K through 12 institutions, there were specific things we wanted. So now we're looking at allocating $30 million worth of grants to private and public colleges. What's the expectation we have? I'm asking because I have 5 universities in my district, and I'm concerned about what we're going to be asking to do with these grants we're going to give them.
Chair Lady Hazelwood.
thank you, Mr. Chairman. These are non-recurring funds. The institutions can apply for them to use anything that's related to safety. I would encourage those institutions not to take on recurring expenses with these grant funds unless they have the wherewithal to fund them in future years. But these could be for hardening of campuses. It could be for additional security, for particular events, for things. Again, I would just encourage institutions to be mindful that these are one-time monies and to be used in that fashion. But anything that's related to safety, we're not trying to dictate to the universities or college campuses. We feel like they know their needs better than we might know, and that those would be very different from campus to campus.
Representative Love.
Thank you, Chair Lady. Thank you, Mr. Chair.
Thank you. Chairman Williams.
Thank you, Chairman. Thank you, Chair Lady Hazelwood. The interesting part about this is for years we have funded multiple dozens of millions of dollars for institutions, K-12 institutions, but rarely have we spent any money in this space. And so this is the first time you've seen this body do this. The speaker really felt like this was really important for us to do, particularly not just including our public institutions, but those private institutions across the state as well, to give them the same opportunity to make improvements around their campuses, because we believe that those campuses aren't immune to the same things we've seen in our K-12 campuses. So appreciate the sponsor of the amendment and description of it. Thank you.
Thank you, Chairman Williams. Further discussion on the amendment. Leader Camper.
Thank you. Just one last question for the record, Madam Chair. It appears in the amendment that there will be some reporting mechanism back to us with respect to the expenditure of the funds, who applied, who was denied, and all of that. So for the record, is that your intention to make sure that the public have an appreciation of, where the funds are going?
Leader Camper, that is certainly our intention, and why that requirement, if you will, was included in the amendment. I think it's incumbent upon not only for public knowledge, but we need to know as a body how these funds are used. And when we come in here next year or back in January for session, then I think it's important that we have an idea of where the funds were utilized, and whether or not that is something, assuming that the message that we got earlier today from Director Thurman and our F&A commissioner, assuming that they're wrong and the world is a rosier place. If we could, again, fund some of these sorts of things, I think it would be very helpful for us to know, number one, where the funds were used, were they effective? And number two, where we were not able to fund just for lack of funding, what other good ideas might have been out there that we might want to consider.
Leader Camper.
Thank you. That's one of the things I appreciate about it, is because it'll also tell us where there's a need. And so there may be a need that we may not necessarily have known about, but would be revealed in this report. And then from there, we can determine if there are additional funding needed and where they need to go. So I do appreciate having that reporting mechanism in there, because it can tell us a lot more of what we perceive the need is versus what the actual need is. So thank you for including that.
Thank you, Leader Camper. Chair Lady Hazelwood, follow up.
Questions or?
All right, further discussion again on the amendment 9634. Hearing none and seeing none, we're now voting on amendment drafting code 009634 on to House Bill 77. All those in favor say aye. All those opposed, no. The ayes have it. We're back on the bill as amended. That brings us to amendment number 4. Amendment number 4 is drafting code 009627. Do we have a motion and a second? We have a motion and a second. Chair Lady Hazelwood, you recognize.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. This amendment allows us to use $50 million non-recurring funds from 10-care reversions, not 10-care reserves, but 10-care reversions, to fund provider rate bonus for our mental health care providers. I think it's no secret that we are having difficulty finding mental health providers who are willing to take care of folks at the rates that we've been paying. This will hopefully incentivize them to continue to care for those Tennesseans who need that sort of help, and will allow us to keep these folks, our providers, on board, so that we can provide the necessary, have access to the necessary care that we need for Tennesseans who have mental health issues.
All right, thank you very much for this description. Members, any discussion on the amendment 009627? Hearing none and seeing none, we're now voting on the amendment 009627 on to House Bill 77. All those in favor, please say aye. All opposed, no. The ayes have it. We're back on the bill as amended. That brings us to amendment number 5. Amendment number 5 is going to be drafting code 009630. Do we have a motion and a second? We have a motion and a second. And Chair Lady Hazelwood, you are recognized on the amendment.
Thank you, Mr. Chairman. And we do have a revision to this amendment that legal is working on for us. So if you could just give us a few minutes to get that in place, it would be appreciated.
Okay. All right, without objection, we stand in recess for 5 minutes. All right, we are back in order. And again, so let's pick up where we left off, which we're on Amendment Drafting Code 009630. And the chair lady was describing that said amendment, so I'm going to recognize her at this time.
Thank you, Mr. Chairman. I move to withdraw Amendment 9630.
All right, you've heard the request to withdraw Amendment 009630. Any objection? Seeing none, amendment is withdrawn. All right, that brings us to, again, a Fifth Amendment, which actually will be Fifth Amendment. It's untimely filed. So without objection, any objection to hearing an untimely filed amendment? Seeing no objection, we will hear the amendment. The amendment is 009638. Do I have a motion and a second? You have a motion and a second. Chair Lady, you're recognized.
Thank you, Mr. Chairman. This amendment would appropriate funds to cover the cost of 10 million, I'm sorry, for Joel. All right, Mr. Chairman, thank you. Again, there are several sections to this amendment. The first section would appropriate funds in the amount of $10,000 non-recurring to implement Senate Bill 93, House Bill 26, that regards reporting of juvenile commitments if that bill were to become law. The second section is $2.49 million recurring. That would be to implement Senate Bill 80, House Bill 27, if those bills become law. That bill is relative to court-ordered mental health evaluation and treatment for criminal defendants. The third section is appropriating $2.321 million for the purpose of implementing House Bill 32, Senate Bill 91. That is relative to mental health coverage and reimbursements if that bill becomes law. The next section is $10,164,500. That is recurring. $9,766,800 shall be allocated for incarceration costs. That is for the sole purpose of implementing Senate Bill 77, House Bill 34. That bill is relative to stalking offenses if that bill becomes law by this body. The next section is funding provisions appropriated $2.4 million recurring, $434,700 shall be allocated for incarceration costs. That is to implement Senate Bill 27, House Bill 73. That is relative to the blended sentencing for certain juvenile offenders if that bill becomes law. The final section is funds appropriated to the Department of Correction earmarked in the sum of $20 million non-recurring for implementation of Senate Bill 27, House Bill 35. That is relative to student loan repayment grant program for certain eligible licensed physicians, psychologists, and counselors, again, if that bill does become law. With that, Mr. Chairman, I would move approval of this amendment.
All right, thank you, Chair Lady. Members, you've heard the description of the amendment, drafting code 009638. Any discussion? Leader Camper.
Thank you, Mr. Chairman. Madam Chair, I registered my concerns to you, but I wanted to, for the record, just say that, I would have liked for this body to have heard from the sponsors on these bills before we vote for this particular amendment, although there are some things in the amendment that I support, that I'm probably going to vote for when the bill comes before us. But I think we should have heard from these bills before we adopted this particular amendment. So that was a little concerning to me, but I understand, the situation we're in, a special session, and things are moving fast. But I would have liked to have heard from the members on these bills before we actually taken a vote to fund them. And I know it's only if the bills pass, and I get all of that, but generally we will have heard, and in this case, we're going to hear the bills after adopting this amendment. Thank you, Mr. Chairman, Madam Chair.
Chair Lady Hazelwood, would you like to respond?
Again, as Leader Camper has noted, this is a provisional approval. Obviously, if the bills are not approved by the body, then these dollars will remain in the general fund and will not be allocated. So there will be ample time, I'm sure, for discussion of the bills as we move forward through this process.
All right, further discussion on the amendment 009638. Hearing none and seeing none, we're now voting on amendment 009638 on to House Bill 77. All those in favor, please signify by saying aye. All those opposed, no. The ayes have it. We're back on the bill as amended. All right, and I have no more amendments at this time. So we will ask legal at this time. Without objection, we're going to ask them to roll all of these amendments into one. So without objection, seeing none, so moved, all these amendments will go into one. All right, any discussion on the bill as it has been amended? All right, hearing none, seeing none, we're now voting on House Bill 77, moving on to full finance. 7070. Yes, 7070. I'll learn to speak. All right. No further discussion. We're now voting on House Bill 7070, moving on to full finance. All those in favor, please signify by saying aye. All those opposed, no. The ayes have it. House Bill 77 moves to full finance. All right, that brings us, members, we're going to now be moving on to Addendum 1 calendar. Item number 1 on that calendar is House Bill 7027 by Leader Lamberth. You have a motion and a second, sir. You are recognized on House Bill 7027, or 7027. Yes, sir, that's correct.
Thank you, Mr. Chairman, and I apologize. It took me a moment there to get to the podium. So there's no amendments on this bill. This bill literally is very simple. We put the law back like it was about 15 years ago. When someone is charged with a crime, it is the state of Tennessee versus that individual. Whether it's a felony or a misdemeanor, the state of Tennessee is charging the person. And unfortunately, in tough budget years a long time ago, they removed funding for mental health evaluations from misdemeanor defendants and only funded felony defendants to have a mental health evaluation. If we can get involved early in someone's diagnosis, early in someone's criminal history, can intervene at the very beginning, then it will make sure that that person gets the help that they need. So this just puts it back the way it used to be, so that the state of Tennessee is picking up the cost for those mental health evaluations.
All right, Leader, thank you very much. Members, you've heard the description of House Bill 7027. Any discussion? Hearing none and seeing none, we're now voting on House Bill 7027, moving on to full finance. All those in favor, please signify by saying aye. All those opposed, no. The ayes have it. House Bill 7027 moves on to full finance.
Thank you, Mr. Chairman, members of the committee.
Thank you. All right, that brings us to item number 2 on the Addendum 1 calendar. That is House Bill 7006 by Chairman Sapicki. I don't see him, so without objection, we'll roll him to the hill. Without objection, so moved. That brings us to item number 3 on that, on House Bill 7023, again by Chairman Sapicki. I do not see him, so without objection, we will roll House Bill 7023 to the hill. Without objection, so moved. That brings us to item number 4 on our bill. Item number 4 is going to be House Bill 7034 by Chairman Grills. Is Chairman Grills? There he is. You have a motion and a second, sir. You are recognized on House Bill 7034.
Thank you, Mr. Chairman. We have an amendment for clarification. It's a technical.
That one's traveling, sir. You're ready.
Okay, fantastic.
You're in correct posture.
Thank you, committee, and all y'all's hard work and your time. What we're doing with this bill is we are increasing the penalties for stalking and aggravated stalking, and we're requiring an independent professional mental health assessment of a defendant to determine their need for mental health treatment if the person is convicted of stalking, aggravated stalking, or especially aggravated stalking. The court may waive the assessment if there was adequate assessment conducted prior to the conviction. And there, as a condition of bail or pretrial release, the defendant may also be required to undergo an evaluation.
All right. Thank you, Chairman, for the description of House Bill 7034. Any discussion? Hearing none and seeing none, we're now voting on House Bill 7034, moving on to full finance. All those in favor say aye. All those opposed, no. The ayes have it. House Bill 7034 moves to full finance. All right, that brings us to item number 5. Item number 5 on our calendars, House Bill 7063 by Chairman Rudd. I do not see Chairman Rudd, so without objection, we'll roll House Bill 7063 to the Hill. That brings us to item number 6. Item number 6 is House Bill 7073 by Chairman Vaughn. You have a motion and a second. I'll give him just a second to get to the podium. Sir, you have a motion and a second on House Bill 773. You're recognized.
Thank you, Mr. Chairman and committee. I bring you this bill today on behalf of Speaker Sexton. It's a blended sentencing bill. We've gone through a great deal of testimony and arguing at some point about the merits of the bill up to this point in both criminal justice sub and full. But as a result of some of that dissertation going back and forth, we're offering you an amended version today of what was actually approved yesterday in criminal justice.
Chairman Vaughn, let's get an amendment on drafting code 009589. Is that correct, sir?
We are in sync.
All right. We have a motion to second. You're recognized. You'd like to put the amendment on and discuss the bill?
Yes, sir. That makes the bill in its entirety.
All right. Then any discussion on, again, we're on amendment 009589. Any discussion? Hearing none, seeing none. We're now voting on the amendment onto House Bill 7073. All those in favor signify by saying aye. All those opposed, no. The ayes have it. Back on the bill as amended. Sir, you're recognized.
Thank you, sir. And the purpose of this bill is twofold. Number one is to seek to give juvenile court judges more authority over cases in their jurisdiction. But when someone commits a crime later on during their teen years of a particularly heinous nature, that they can be bound over to the age of 24. We will stop the situation where someone could actually, a rape victim may come into contact with their rapist within 2 years of the commission of the crime. And so what the items that we're proposing that we have the blended sentencing for are indeed rape, aggravated rape, rape of a child, aggravated rape of a child, aggravated robbery, especially aggravated burglary, kidnapping, aggravated kidnapping, not just normal kidnapping, but aggravated kidnapping, especially aggravated kidnapping, terrorist act, carjacking, aggravated child abuse, or any other Class A or B felony that involves the use of a deadly weapon during the commission of the offense. And so what this does is it allows the juvenile court judge to give them a sentence up to the 19th birthday. And after that point in time, they can extend the sentence beyond that if the perpetrator or the delinquent has not done 3 of the following 6 items. Yesterday we argued about all 6. We have reduced the requirement down because there are occasionally extenuating circumstances that we want to allow the judge a little bit more discretion. But if they have committed another delinquent act, engaged in conduct that creates a substantial security risk, or fail to meet the conditions of supervision, so basically not doing what they've agreed to do, if they have failed to attend school regularly with passing grades, or graduated from high school or gotten their general education, their GED diploma, or if they failed to obtain regular employment, then the juvenile court judge can make sure that they stay in custody falling under the court's jurisdiction until they're age 24. And the way that is given is that if they commit a Class A felony or Class B felony, Class A felony is 4 years, 3 for Class B felonies. Now then, there's another portion of the bill that has to do with blended sentencing. The other is a transfer bill. Transfer bill says that if a 16 or 17-year-old commits first or second degree murder, that they're going to be tried in an adult court. And so that's the bill in a summary basis, but I'll stand for any questions.
All right. Thank you, Chairman Vaughn. Members, you've heard the description of House Bill 7073. Any discussion? Representative Shaw.
Thank you, Mr. Chairman. Thank you for the legislation. I just want to be clear that age 24, if they should continue in the vein of committing crimes, does the judge have the discretion to continue with them as juveniles, or what happened? Do they go to adult court? Can you kind of explain that piece to me?
It depends on what, if they're arrested for another offense, it would be dependent upon that offense, what's going on with it. But if what this does is it says, okay, for the original offense, but one of those heinous crimes that I mentioned, if they're not doing what it takes to demonstrate true rehabilitation during the time that they're within the juvenile system, then the juvenile court judge can keep them till they're 24.
Okay.
But if they commit another act, then it would be based upon their time there in the situations that are there. But by them committing another act, it eliminates one of the possibilities for them to be able to shorten up the stay.
Okay.
Representative Shaw.
But the judge has the discretion. It doesn't change the fact that the judge can just immediately try them as adults if he or she feel that is necessary.
If a DA and a juvenile court judge get together and decide that this court needs to be remanded to adult court, this does not get in the way.
Okay. Thank you.
Thank you. Representative Love.
Thank you, Mr. Chairman. And sponsor, I was listening to what you were saying, and I want to make sure I heard you correctly. You mentioned something in relation to not graduating from high school.
Yes, sir.
What does that do if the juvenile does not graduate from high school?
There are 6 things there's a list of 6 actions that they need to take, that we believe they need to take to show a corrective behavior situation. And let me get back to those. I have them highlighted over here. So these are the 6 things that if you don't do this, only half of them, you don't have to do all of them, but if you don't do half of them, and graduating from high school is one of the things on the list. So I understand things happen to people. They may not graduate from high school, but if they just don't commit another delinquent act, don't create a safety risk when they're under supervision, and meet the conditions of their supervision, then those are things that that gives them the judge the flexibility to stay the additional time. Or if they have done something, but they have gone on and attended school regularly and passed, or graduated from high school or gotten a job, then that takes the place of one of the first 3 things. So what we're trying to do is, we're not saying, hey, if you don't graduate from high school, you can't get out of your blended sentence on the adult side. What we are saying, though, is you got to take some steps. And this is different than the version that we heard yesterday in criminal. We did have that they had to do all of these things. Now we're saying you have to do half these things to demonstrate a good faith effort to show people that you're really about turning your life around and don't need to be under the supervision of a juvenile court judge anymore.
Representative Love.
Thank you. A few years ago, this body passed and is now law, a piece of legislation that highlighted adverse childhood experiences, and understanding that sometimes, as much as we may want to, children may experience things in their life that have an adverse effect on them. Nobody wants a child to go through that. So my concern is that a juvenile who may have committed an act that now puts them in position that if they don't do other things, including graduate from high school, that if we put that in as a punitive measure, then this is not going to incentivize them to do something that maybe many of us think is just a normal course of life. And I would suggest to you that if a juvenile is in a situation where they are committing an act, then there is something going on in that child's life that we may want to look at and consider incentivizing them to do the right thing. When we talk about pouring money into programs that deal with restorative justice and programs that deal with giving children opportunities to choose the right path, those are a way to incentivize, I believe. And I'm speaking as a lifelong resident of the city and watching how it's grown, and also watching how, of course, things have happened with our juveniles, but also as one whose whose mother was the director of a program called Upward Bound for 57 years, taking first generation kids, getting them ready for college. And many of them still testify today that if she had not intervened in their lives, they would have gone another path. And so for me, that's a concern, is when we have graduate from high school as a punitive measure, or not graduating rather, that it gives me deep concerns about this particular bill.
Chairman Vaughn.
Thanks, sir. And I appreciate that, Representative Love. Okay, so let's say that we have someone that, for whatever reason, let's say they're not capable of graduating high school or getting a GED. If they will not commit another delinquent act, if they will not engage in dangerous behavior, if they will follow what their probation officer tells them to do, or if they just get a job, any three of those four things is the threshold we're putting before them. So I don't believe that this excludes anyone who wants to be a productive member of society to achieve that. And let me tell you about another thing. This is simply an additional tool that we're giving our juvenile court judges to hopefully crack down on this revolving door that we're seeing in a number of places. Juvenile crime is up 31% in Shelby County this year, year over year. And those are statistics from the Memphis Crime Commission. But what we're also doing as a legislature, what we funded last year was a program through Memphis Youth Villages, which is called Memphis Allies. They received over $3 million of funding from this body. It was a legislative initiative driven by our body that has to do with providing mentorship, providing folks that can go and find out and sniff out the root causes of what's causing problems. And so this is one of those deals to where we're going on both ends of the spectrum to say, hey, we're willing to invest in young people to get the recidivism rate down, to intervene where the state can intervene. But this also is saying that if habitual offenders and extremely violent offenders are going to have an opportunity to pay a bigger price for their, hopefully, and that will serve as a deterrent. So between working at it from both ends of the spectrum, we all want the same thing. We want to get crime curtailed. And so this is the other end of the spectrum from a program like Memphis Allies.
Representative Love.
Thank you, Mr. Chairman. And I do appreciate you bringing those programs up. Again, what gives me pause is this. Oftentimes when we have programs that work on the other end of the spectrum to incentivize the right behavior, sometimes we don't give those programs time to actually take their effect. And so the program that you're talking about, if it was implemented last year, we may not see the results of that until this year. And I'm thinking now about even a bill we passed, I believe, that said that if a child tried to escape from a youth detention center, then they would then be sent to an adult court. I believe that's how the legislation works. And so my concern is that we should allow these measures that we have put in place to incentivize to take their full effect, and then see what measures we need to put in to then work on the other end. And I'm just basing on a conversation also I had with my juvenile court judge, Sheila Calloway, who called me and said, listen, this is not what we want. We'd prefer to be allowed to do some other things that will, again, reduce our juveniles going into situations. So those are just my concerns I have. And I'm hoping that we take very seriously consideration about the long-term effects we will have with these incarceration and blended sentences. So thank you again for hearing me out.
Chairman Vaughn.
Yes, sir. Just a point of clarification. Memphis Allies was funded during its first year through local dollars in the Memphis community, many of which were private. The state, we came in this year in our second year, so we should be getting some good data to determine whether or not, that's one of the things I want to find out is what type of effect, what type of investment our dollars are giving us for that. We've got to get a handle on what's going on in some of our communities, because if not, it will choke the life out of our communities. And that's what we're trying to do here. This is not something to where we're saying, hey, we want to drop the hammer on people, but we do recognize the fact that sometimes the judge does need to have a hammer. And this is what we're doing with this. But I appreciate your comments.
All right, thank you, Chairman Williams.
Thank you, Chairman. Thank you, Chairman Vaughn, for this bill. I think what doesn't need to be lost here is that this is an exhortation to a young individual whose past behaviors might determine or predict their future behavior. And by giving them not a strict set of guidelines, but an open, choose your own path version of this, it encourages those who have victimized others not continue to do so. And so I really appreciate this bill. I think it's important that we do that because unfortunately, at times, young people don't understand that their behaviors or the things that they do create victims and create other problems. And so if they can get, as you said, whether or not they get their high school diploma, but if they get a job and they participate and they just do what's expected of them, because some young people in my community and probably in yours don't have those requirements. Something as simple as showing up when you're supposed to and going to work when you're supposed to. Those things can change the trajectory of an already challenging situation. So I really appreciate this bill. I think it's important, particularly in districts like yours and here in metropolitan Nashville. But I appreciate you stewarding this and having the flexibility of not being so strict and saying you have to do all 6, because if that were the case, then I think my good friend from Nashville's concerns might be more valid. But having the opportunity and flexibility to choose 3 of 6 makes a huge difference. And so I really appreciate the bill.
Chairman Vaughn?
I'd like to say thank you. And, you know, that's part of sometimes the painful part of this process that we engage in is somebody calling your baby ugly. And then you have to try to figure out how to get it into shape to where it is a better piece of legislation. And that's what we did is we listened to the criticism of it. Some criticism was struck at the foundations of it, but others brought about real things that were unintended that we addressed through this amendment. And and I believe we got those repaired. The last thing that I would point out is that if you think back, and I hate reading the list because it's a pretty vile list of offenses. This isn't rolling somebody's yard or egging their house or even driving off in your friend's dad's car without permission. These are violent crimes which leave victims in their wake. And sometimes incarceration helps people get rehabilitated, but every time incarceration separates the perpetrator from the victim. And so even if we run into somebody that's a hardened criminal, we're at least going to give victims relief of not having to run into them down the street in a short period of time. And so with that, I'll close and answer any additional questions, Mr. Chairman.
Thank you, Chairman. Leader Camper.
Thank you, Mr. Chairman. Mr. Chairman, I was looking for the fiscal note for this new amendment. I didn't find it on the dashboard. And I think, we just voted on the appropriation amendment to fund this. And I was looking for if you have a copy, I'd like to see, because I can't find it here.
Okay, we have
And,
your copy coming.
Okay, thank you. I appreciate it. I'd like to look at that. And so thank you for that. Mr. Chairman, you said last night, late into the night, you all came up with a compromise of sorts where you amended and came out with the new amendment. Could you kind of highlight for us what some of those are? I know that from the 6 to the 3 was one thing. Was there some other stuff that you all worked on? Because I know we've been working on blended sentencing for years, even when Judge Dan Michaels was the juvenile court judge in Shelby County. It was something he was trying to pioneer years ago. I know Representative White and Hardaway worked with him on that years ago. And so I'm just curious, some of the compromises that you made in committee last night, if you could point those out, that'd be helpful. Thank you.
Yes, ma'am. One of the issues that we addressed was the potential for having an offender through a series of events wind up serving more time for an offense than an adult would. We put a floor of 14 years old in this, which prevents that math from working out.
Okay.
That was one of the reasons. Let's see. We reduced we had added in there that Class C felonies would result in a 1-year addition onto their sentence. We removed that. So Class C felonies, so we're only dealing with Class A and Class B felonies. We put a floor on the age, and we gave more flexibility for them to demonstrate that they're straightening out.
Leader Camper.
Thank you. Thank you, Mr. Chairman. I'll look this over.
Okay.
Appreciate it.
Representative Shaw.
Thank you, Mr. Chairman. I'll be very brief. I thank you for bringing it, and I totally agree with you that we need to start somewhere. I think I just want us to be agreeable and being amenable to, as we move through this process, if we see something that is hindering that youth from accomplishing the things that you laid out to overcome, I assume we would all be amenable to amending this to say, well, we left this out. We need to do this to make sure that that youth get an opportunity to change, to turn their life around. I'm sitting here trying to think, what is it in the system that might block them from accomplishing one of those three things you brought up? If that is the case, that's what I'd like to see us do, is to make sure that we remove any barriers that would keep that person from accomplishing that.
Hold on one second, Chair. Members, that fiscal note is on dashboard now if you'd like to jump on and take a look at it. So just letting you know that. Chairman Vaughn.
Well, Representative Shaw, the intent of this legislation is to have less youth committing crimes that put them into the system. And we know that up here sometimes we do things with the greatest intentions, and they turn out not to be the best. We don't get the results that we intended, so we have to come back and look another way to solve the same problem. I think that all sides of this, everybody wants to reduce youth violent crimes, and particularly that we see them occurring in larger metropolitan areas. And so if something in here winds up not being effective or creating for lack of a better term, a trap that keeps people from achieving their goals and achieving the goals that we all want, which is just a safe society, then surely this legislature will come back and look at this program to see what we can do to lack of a better term, build a better mousetrap. But we're seeking the same thing. It's just some people may disagree with other people's methods.
All right. Thank you very much. I have no one else on the list. So we are now voting on House Bill 7073 being sent on to full finance. So all those in favor signify by saying aye. All those opposed, no. The ayes have it. House Bill 7073 moves to full finance.
Thank you, Mr. Chairman and committee.
All right, I see Chairman Rudd back there. So let's move back to item number 5. Item number 5 on our calendar is going to be House Bill 7063. You have a motion to second. Chairman Rudd, you're recognized for brief description.
Thank you, Mr. Chairman. This is very simply a bill that is needed because as we've been alerted to the SRO program, we're finding it hard to find enough deputies to go around, and especially this is a problem in rural areas. And if a county or a city runs into this situation, this bill simply opens up SROs under certain conditions and training to include retired police officers and veterans.
Okay, thank you very much. Members, you've heard the description of House Bill 7063. Any discussion? Hearing none and seeing none, we're now voting on sending House Bill 7063 on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes have it. House Bill 7063 moves to full finance.
Thank you.
Thank you. I saw Chairman Sapicki come in. I don't know if he's out in the hall. If he is, there we go. All right, members, we're going to back up a little bit more, and we're going to go to item number 2 on this calendar, House Bill 7006. Again, by Chairman Sapicki. You have a motion to second. Sir, you're recognized for a description.
Chairman, I do apologize. Chairman, Leader Lambert was out there talking to me, so I'm going to blame him on this one. This bill does 2 things very simply, members. The Department of Mental Health and Substance Abuse Services may direct available funds as appropriated to contract with additional private sector providers across the state to provide inpatient psychiatric services for uninsured individuals in the state. And then it directs the Department of Mental Health and Substance Abuse to submit a report to the Speaker of the Senate and the Speaker of the House of Representatives on whether additional inpatient psychiatric services are needed in the city of Knoxville, Tennessee. The report must include recommendations on whether additional state funds should be expended for the construction of a state-owned and operated inpatient psychiatric facility. That's what it does, Mr. Chairman.
All right, thank you, Chairman Sapicki. Members, you've heard the description of House Bill 7006. Any discussion? Hearing none and seeing none, we're now voting on House Bill 7006, moving on to full finance. All those in favor signify by saying aye. All those opposed, no. The ayes have it. House Bill 7006 moves on to full finance. Brings us to item number 3 on our calendar. Item number 3 is House Bill 7023, also by Chairman Sapicki. Do we have a motion to second? We have a motion to second. Sir, you're recognized for a description.
Thank you, Mr. Chairman. It'll be a brief description. If a local board of education has not entered into a memorandum of understanding with the law enforcement agency to assign school resource officers at each school within the local board of education's control, then the law enforcement agency with jurisdiction may assign at least one law enforcement officer to serve as a school resource officer at the school to increase the protection and safety of students and school personnel during regular school hours when children are present on school premises, as well as during school-sponsored events. That's the bill, Mr. Chairman.
All right, thank you, Mr. Chairman. Members, you've heard the description of House Bill 7023. Any discussion? Representative Love.
Thank you, Mr. Chairman. And Chairman, we discussed this yesterday in Education Committee. As you know, I have concerns about this piece of legislation, particularly the section where law enforcement can send a law enforcement officer to the school that may not have the training to be an SRO.
Mm-hmm.
School cannot impede the law enforcement officer from going there. And so those are my concerns, but I also want to, I think there was a bit of maybe confusion yesterday about whether Davidson County and Metro Public Schools had an MOU. And just want to enter into the record, they did send me the MOU between Metro Public Schools and Police Department. So Metro has an MOU with the Police Department. And they just want to, I think, make sure that when law enforcement is sent to the schools, that they may be dressed a little bit differently than traditional law enforcement. Maybe, from my understanding, I've been told that if they could have situations where law enforcement is dressed down a little bit, then the students may be more incentivized to have conversation with law enforcement about problems in the school. And so I can't support the bill because, again, I'm deeply concerned about the superintendent of schools and the principal getting a notice from law enforcement that a law enforcement officer is being sent to the school without being asked to, and this is just for a regular day. This is not for an emergency. This is not if there's an emergency there with any number of things. This is just if the chief says, go to this school and you're going to be the law enforcement officer there. So my concern is with that, and I think I expressed it to you yesterday. Thank you.
Thank you.
Thank you. Chairman Sapicki, comment? Chairman Williams.
Thank you, Chairman Sapicki. I haven't had a chance to hear about this bill until we got to this committee, but I just want to clarify. So if there was an LEA who, for whatever reason, chose not to have an SRO in one of their facilities, what your bill would do would allow that local agency, whether that had an MOU, to be able to assign a law enforcement officer there, so that they're for prevention purposes instead of there just to react if there were an incident. The purpose for this is so that those schools whose LEAs chose not to get an SRO of their school, this would allow the local law enforcement to be able to assign someone there and use the $80 million of unconsumed resources that this body set aside for SROs last year. Am I correct?
Chairman Sapicki.
That is correct, sir.
Thanks, sir.
Thank you. Further discussion, House Bill 7023. Hearing none and seeing none, we're now voting on House Bill 7023, moving on to full finance. All those in favor signify by saying aye. Aye. All those opposed, no. The The ayes have it. House Bill 7023 moves on to full finance. If
Thank you,
you'd like to
Chairman,
be
Committee.
recorded as a no, make sure the clerk sees you.
Madam Chairman, I will not be late.
All right. Chairman Grills make his way back. I haven't seen him come in. Okay, we'll move on back in order to item number 7. Item number 7 is House Bill 7012 by Chairman White. You have a motion and a second. Give you a second to get prepared there at the.
Thank you,
well.
Chairman, Committee.
Chairman, you have a drafting code, an amendment drafting code 009588. Is that correct?
9541 or 9588?
I have 9588.
Okay, we'll go with that. I had the last one I had was 9541. Maybe it's changed again.
Okay. So we'll put that amendment on and then we'll let you describe the bill. Okay, we have a motion and a second on the amendment. Any discussion on the amendment? Hearing none, seeing none. We're now voting on amendment drafting code 009588 on to House Bill 7012. All those in favor signify by saying aye. All those opposed, no. The ayes have it. We're back on the bill as amended. Mr. Chairman, you do have the floor for a description.
Well, thank you. Thank you. And I apologize. That was the last amendment added to there. And I will describe that. What this one, I'm bringing this bill before the committee on behalf of our speaker. It deals with, this is on behalf of the administration. During the summer, we worked on some things for safe storage of firearms. This is Department of Safety does 4 things. She'll provide free firearm locks to a Tennessee resident upon resident's request. And number 2, the Department of Safety with all the Tennessee Bureau, with the TBI and other state agencies, as the department deems appropriate, to create a public safety campaign dedicated to firearm station storage, PSA. Item number 3 in the bill, all department approved handgun safety courses shall include instruction on the safe storage of firearms. In the amendment that you mentioned, it also just grandfathers in any previously conducted courses into this bill. And the last item is there's an exempt tax imposed by this chapter in the retail sale of firearm safes and firearm safety devices. So safe storage bill that comes out of the administration.
All right. Thank you, Chairman. Members, you've heard the description of House Bill 7012. Any discussion? Hearing none and seeing none, we're now voting on House Bill 7012, moving on to full finance. All those in favor, please signify by saying aye. All those opposed, no. The ayes have it. House Bill 7012 moves on to full finance. Thank you, Chairman. That brings us to item number 8, House Bill 7033 by Chairman White. We have a motion and a second. We have a motion and a second, sir. You're recognized.
Thank you again, committee. This one is the one that was brought to me by our speaker. It deals with bailable offenses, and it puts accountability in the system. Mainly what it does, it says when a person receives bail for an offense on arrest, that the clerk of the court within 48 hours shall publish a list with just 3 items on it: the offense for which the defendant was omitted or they received bail, the amount and conditions, if any, of the defendant's bail, and the name of the magistrate, judge, or judicial official or clerk admitting the defendant's bail. Mainly to let the public know what went on when a person who's committed an offense is receiving bail. It's accountability bill.
All right. Thank you, members. You heard the description of House Bill 7033. Any discussion? Hearing none and seeing none, we're now voting on House Bill 7033, moving on to full finance. All those in favor, please signify by saying aye. All those opposed, no. The ayes have it. House Bill 7033 moves to full finance.
Thank you, Chairman, committee.
All right. Thank you, Chairman. All right. Item number 10 will be our next item on our calendars, House Bill 7032 by Chairman Williams. We have a motion and a second. We have a motion and a second. Sir, you're recognized for a description.
Thank you, Chairman and members. This bill was brought to me by the Speaker as well. What this bill does is it sets a new rate in parity with mental health and substance abuse reimbursements for across our state. As many of this body knows, reimbursement rates are so low as it relates to mental health services. A lot of mental health services are not able to be provided in our local communities, sometimes creating deserts for mental health services. What this bill would do is make it more profitable for businesses to come to Tennessee and provide mental health services or grow their existing services so that these individuals, whether inpatient or outpatient, that those services can be met. and help cover some of the expenses which are occurred in those areas for that. It's my hope and the speaker's hope that this bill would provide much needed resources to our local communities as it relates to mental health services. With that description, Mr. Chairman, I'm happy to answer any questions.
All right, thank you, Chairman Williams. Members, you've heard the description of House Bill 7032. Any discussion? Hearing none and seeing none, we're now voting on House Bill 7032, moving on to full finance. All those in favor, please signify by saying aye.
Aye.
All those opposed, no. The ayes have it. House Bill 7032 moves to full finance. All right, that brings us to item number 11. Item number 11 is Chairman Zachary. House Bill 7026. You have a motion and a second. Sir, you're recognized.
Thank you, Mr. Chairman and committee. Mr. Chairman, I have an amendment drafting code 9481.
That is traveling with the bill, so you are in the proper
Very
posture,
good.
sir.
Thank you, sir. Members, currently in 3917, 1316, it makes clear that if you've been adjudicated mentally defective or mentally institutionalized, you are now not allowed to possess a weapon. Going through the governor's task force this summer, TBI pointed out to us that there's a gap in the system right now where if juveniles 16 and up who are adjudicated mentally defective or been mentally institutionalized, when they hit 18, their record is clearing, which would allow them to buy a weapon. This bill corrects that. It ensures that information flows up into TICS. Everything else remains the same, but ensures that information moves up. So when they do turn 18, they're not allowed to purchase a weapon. With that, I'm glad to answer any questions.
Thank you, Chairman. Thank you for this description. Members, any discussion on House Bill 7026? Hearing none and seeing none, we're now voting on House Bill 7026, moving on to full finance. All those in favor, please signify by saying aye. All those opposed, no. The ayes have it. House Bill 7026 moves to full finance.
Thank you, Mr. Chairman and
Thank you,
committee.
Chairman. All right, we will now move to the Addendum 2 calendar. These are the bills, just to make sure everyone is up to speed here where these bills came from. These bills actually came from GovOps from this morning. So that's where these bills have come from. So we're going to begin at item number 1 on Addendum 2 calendar. Item number 1 is House Bill 7035 by Representative Gillespie. You have a motion and a second. Sir, you're recognized on House Bill 7035. It looks like we have an amendment drafting code 009632. Is that correct?
Yes, sir, that is correct.
Okay, we have a motion on the amendment. We have a motion and second on the amendment. Would you like to put this amendment on and then describe the bill as amended?
Yes, if that's okay.
Okay, that will work. Any discussion on the amendment? Hearing none and seeing none, we're now voting to attach amendment drafting code 009632 onto House Bill 7035. All those in favor, please signify by saying aye. All those opposed, no. The ayes have it. We're back on the bill as amended. You're recognized, sir.
Thank you, Mr. Chairman and committee. This bill comes from Speaker Sexton and myself, and what we're doing here is we're trying to fill the shortage of mental health professionals in the state by creating a way for student loan forgiveness through a grant program for people entering into the fields of psychiatry, psychology, and mental health counseling. And there's a lot more to it that I can go into as much detail if you'll need me to. But with that, I welcome any questions.
All right. Thank you very much, Representative Gillespie. Members, you've heard the description of House Bill 7035. Any discussion? Leader Camper.
Thank you, Mr. Chairman. Could you discuss the amendment that we put on?
Representative Gillespie.
Yes. Thank you so much, Mr. Chairman. Leader, what the amendment that we just put on does is it's going to take $20 million from the general fund and create a new student loan repayment grant fund. And like I said, that's $20 million for the next fiscal year. And it will prioritize those that apply for these grants to individuals that intend to practice in unserved areas of the state that have no mental health care providers, and in individuals who intend to practice in underserved areas of the state that have shortage of mental health care providers. And it will also prioritize individuals who've graduated from Tennessee schools.
Leader Camper.
Thank you, Mr. Chairman. Does this bill have a sunset provision in it along with an amendment I thought we put on in GovOps as well?
Representative Gillespie.
Thank you, Mr. Chairman. Yes, that amendment that is, I believe, already on the bill, and it's 10 years. that it will be revisited. It is my hope that we will fill this void in less than 10 years, but for those of us here, then we'll address that.
Leader Camper.
Thank you.
All right, thank you. Further discussion on House Bill 7035. Hearing none and seeing none, we're now voting on House Bill 7035, moving on to full finance. All those in favor, please signify by saying aye. All those opposed, no. The ayes have it. The ayes have it. House Bill 7035 moves to full finance. And if you'd like to be recorded as a no, please make sure the clerk records you as such. All right, item number 2 on our calendar for the addendum 2 calendar is going to be House Bill 7038 by Leader Gant. I think I see him. There he is. We have a motion to second. We have a motion to second. Sir, you're recognized.
Thank you, Committee and Chairman. What this legislation does is establishes a first alert system that can be included as an approved expenditure under the grant program that we approved back in the session back in April. And it establishes, the Department of Education shall establish and administer a school safety alert grant program. The purpose of the program is to provide grants to LEAs and public charter schools to establish school safety alert systems in public schools. The alert systems funded, now this was part of the amendment that was put on previously, and the amendment added in consultation with the Department of Safety. So the alert systems funded through this grant program must be approved by the Department of Education in consultation with the Department of Safety. And I know many of you have already heard this, and so I will not go through the entire spiel, but if anybody has any questions, I'm glad to try to answer them.
All right, thank you, Representative Gant. Members, you've heard the description of House Bill 7038. Any questions for our sponsor? Hearing none and seeing none, we're now voting on House Bill 7038, moving on to full finance. All those in favor, please signify by saying aye. All those opposed, no. The ayes have it. House Bill 7038 moves on to full finance. Thank you. All right, members. At this time, any bill that was not taken up today on any of the calendars that we have been through will, without objection, will be taken off notice. Without objection, so moved. And at this time, I'm going to recognize Chair Lady Hazelwood for a full finance meeting announcement.
Thank you, Mr. Chairman. Full finance will meet in House Hearing Room 1 at 1:50. That's 1:50 in House Hearing Room 1. Thank you.
All right, any further business coming before this committee? I see none. We stand adjourned, subject to the call of the chair. Pull it back.